Is there such a thing as privacy anymore? Is it even possible in a digital age where just about everyone is connected to social media through smartphones, Facebook, and Twitter accounts? And when drones can fly just about anywhere, including your own backyard, and take a picture?
Our pictures, information is up on Facebook and other social media sites and on the internet. And sometimes, often, people have voluntarily put that information out there. But that doesn't mean that people don't want to be able to control it and don't think that they still have rights over it and what's done with that information. And so when we conceive of privacy very narrowly, as is sometimes done today, as about secrecy or seclusion, we're missing the broader aspects of autonomy and dignity that are contained within the broader and original concept of the right of privacy. And I think it's important to reclaim that in these aspects of controlling unwarranted publicity, because they enable us in this digital age to still have control over information that we put out there. It's not that we don't want to continue to exercise control over it just because we've made information public. It still is our information.
That's Jennifer Rothman, professor of law and the Joseph Scott Fellow at Loyola Law School in Los Angeles. She's also author of The Right of Publicity, Privacy Reimagined for a Public World.
We all live our lives in public, but by doing so, we should not become public property. The right of publicity gives us all a tool to stop other people from using our identities without permission. Now, sometimes the First Amendment and free speech interests are going to overcome or trump that particular interest, but everyone has this right of publicity.
Anyone who followed Facebook CEO Mark Zuckerberg's testimony before Congress might wonder what happens to their personal information when they use social media.
Facebook is not the only offender here. They're the most high profile, but there are lots of social media sites and others that are taking our information and selling it and taking our images and selling it. And now he's being called for account. But those of us who have been following this know that these sites have been taking our information and selling it and taking our images and selling it. Facebook has used its users' names and likenesses to sell Coca-Cola and other products to their friends. Twitter has set up trading cards with Twitter members and given rights to another company without informing the individuals whose names and likenesses were used. There's so many examples of this happening. And people don't even realize it when they put their images up, or that the terms of services on these sites give permission to these companies sometimes to do this.
However, the concern about the loss of privacy and the right of publicity is not new. It started with a certain technological advance. No, not computers or smartphones, as you might think, but rather with a much older technology, the invention of portable cameras in 1888.
And people went from being sort of anonymous citizens walking down the street to having their pictures taken and then slapped on advertisements or showing up in the newspaper unexpectedly. And so there were these calls for having a state tort law like the state right of privacy.
However, the right of publicity is interpreted differently from state to state because it's a state law, not a federal one.
State tort law is a whole body of law set up by states that's supposed to remedy wrongs, harms to people. So if you get into a car accident, that's a tort. If someone burns down your house, that's a tort. It's also criminal, but it's also a tort, which is a non-criminal charge that you can bring to either stop people from doing things that are harmful to you or your business, or to recover damages for doing so. So today, when we think about privacy rights, we think of all different things. We think of constitutional rights over decisions we make about our bodies, from abortion to contraceptives. We also think of spatial privacy and being able to stop the police from coming into our house or searching our car. We think about all sorts of things like that. But at its origin, the right of privacy in the United States was a state tort law, and it was focused specifically on these unauthorized uses of people's names and likenesses.
Frequently, the right of publicity conflicts with the First Amendment.
The First Amendment is part of the U.S. Constitution, and it says that Congress cannot make laws that limit our freedom of speech. and freedom of the press. And that's been also extended to state laws as well. So if the right of publicity is shutting down speech, then that's something that the First Amendment prevents. But it doesn't prevent it in every instance. So there's a famous case, at least among lawyers, Zucchini v. Scripps Howard Broadcasting, which was a case decided by the Supreme Court of the United States involving a human cannonball act. And the Hugo Zucchini was catapulted out of a cannon, and the nightly news broadcast his entire act, and he sued. And the news station said, we have a First Amendment right to broadcast this act, which was at the county fair. And the Supreme Court said, no, actually you don't.
The Supreme Court said the First Amendment doesn't give you a carte blanche to duplicate entire performances in a newscast, for example.
There have been a number of lawsuits arising out of books and movies where someone thinks that they're depicted in the book or the movie and they don't like that being included without their permission, and they've sued. And usually the First Amendment has defeated those claims unless the person is recognizable, identifiable, and the use is defamatory.
In today's digital age, Rothman says we should all be concerned about the right of publicity. She says there are 3 aspects of the right of publicity in particular that we should be aware of.
The first is this transferability piece, that by turning it into a form of intellectual property, it can be taken away from us. So you might unwittingly, in terms of service on these sites, give Facebook permission to own your name and likeness and to be able to use it how it sees fit, and even to prevent you from using it elsewhere. And Facebook hasn't reached that far, but some reality television shows, for example, have contestants transfer their rights in that way. The NCAA at one point had a contract where student athletes were assigning their rights of publicity to their name and likeness in perpetuity to the NCAA. So that's one of the aspects of transferability that's very concerning to me.
The second is the impact on free speech and the ability to shut down stories and information about real people,
including movies and television shows, but also video games and other stories and even celebratory works of people who have recently died. We might want to have posters, merchandise of them to celebrate in that. And the right of publicity could really be stopping this sort of public discourse and storytelling about real people. And the third concern that I express in the book is about the conflict with copyright law, that someone might have a copyright in works, either photographs or motion pictures, for example, and then not be able to reuse that material in a way that copyright law allows because the people depicted might be able to bar further uses of those creative works.
Case in point, tattoos worn by NBA players, including LeBron James. A video game company is being sued for depicting characters wearing the recognizable tattoos of these players.
There have been a number of right of publicity cases involving uses that aren't of the person's actual name or likeness, but might be a nickname or a red race car associated with someone, and potentially a tattoo. Now, I argue in the book that that is too broad a concept of the right of publicity. If we have those sorts of uses, we might want to have an additional hurdle, like people are actually likely to be confused, for example, that someone endorsed the particular use, rather than just the bare use of someone's tattoo.
So, right of publicity, right to privacy. Which is it?
They're really one and the same and are best understood together rather than apart. The right of publicity is today thought of as this form of intellectual property, and it's all about money. And the right of privacy was thought of as just being about the individual and dignity. But the book tells a story of how the right of privacy originally was broader than just about emotional harm and private figures. It was also about public figures and also about their professional lives and about economic harm to them. And so the right of publicity turns out to be primarily about this transferability piece, about the ability to take the rights away from individuals. And so mostly what we hear about today from celebrities is this right of publicity. But some of the confusion may stem from my main argument, which is that they're best understood together, that the right of publicity and the right of privacy are really very much one and the same.
Jennifer Rothman's book, The Right of Publicity, Privacy Reimagined for a Public World, is available now. You can learn more about Rothman and all of our guests on our website, viewpointsonline.net. I'm Gary Price.